A DIY will that breaks Florida's rules is the same as having no will at all. Florida law has very specific rules for making a valid will. If your will does not follow those rules, a Florida probate court will reject it. Your assets will then pass as if you never wrote anything at all. Under Florida Statute 732.502, every will must meet 3 requirements. First, it must be in writing. Second, you must sign it at the end. Third, 2 witnesses must sign the will in your presence and in the presence of each other. That third requirement is where most DIY wills fail. All 3 signatures must happen at the same time, in the same room. Witnesses who sign separately or sign without watching each other create a will that Florida courts will not accept. Florida does not recognize holographic wills. A holographic will is a handwritten, unwitnessed document. Even if your wishes are clearly expressed in your own handwriting, Florida will not honor it. It must still have 2 witnesses. Some people use a beneficiary as a witness. Florida law allows this, but it creates a problem. A witness who is also named to receive property may lose their inheritance if the will is challenged. Florida Statute 732.5165 addresses when wills become void or voidable. Florida applies a strict compliance standard under Power 732.502. Every execution formality must be met exactly. There is no harmless error exception for wills in Florida. A minor procedural mistake voids the entire document. There is also a common misunderstanding about notarization. A notary is not required for a will to be valid in Florida. However, a notarized self-proving affidavit under Florida Statute 732.503 makes probate significantly easier. It removes the need to track down witnesses after you are gone. Online platforms can produce Florida-compliant documents if used correctly. The problem is the execution process. A template filled in correctly can still fail if the signing ceremony is done wrong. If a Florida probate court rejects your will, the state's intestate succession laws take over. That means Florida law decides who gets your property, not you. In Florida, a will that is not properly executed is not a will at all.